Good evening. Our News Channel 5 Investigates team first broke the story that raised questions about a deal between Nashville's top prosecutor and a high-profile domestic violence defendant.
Now, one legal expert is raising questions about the ethics of that deal. Investigative reporter Ben Hall is here with all the details.
Well, Vicki, Glenn Funk says this type of deal is routine and appropriate, but a University of Tennessee law professor has a different take.
No, it wasn't an ask. It was we're not dismissing your criminal case unless you dismiss your federal case.
David Chase says his rights were violated when he was forced to drop his civil lawsuit against Metro in order to have criminal charges against him dismissed.
In my opinion, blackmailed me to using my criminal case in incarceration as leverage.
The same day Chase dropped his lawsuit, Funk filed this notice of dismissal, detailing how investigators failed to find enough evidence to prosecute, something Chase says they had been telling him for months.
But at the point that they know they no longer have probable cause, there is no ethical question at that point. They just simply have to drop the charges.
UT law professor and associate dean Alex Long told News Channel 5's Phil Williams he questions the ethics of Funk's waiting to drop criminal charges, which Chase says Funk did for months, even though the case had fallen apart.
The prosecutor is putting pressure on someone to drop a potentially valid civil claim through the threat of prosecution that he doesn't have a right to bring in the first place.
Long said prosecutors should not bargain with criminal charges they know they can't prove in order to drop a civil case.
As I read the notice of dismissal here, it sounds as if the prosecution is conceding that there is no probable cause to proceed in this case.
Which means what?
That ethically they need to drop the case.
Glenn Funk defended his actions. In a statement, he told News Channel 5, release dismissal agreements are routinely used by prosecutors throughout the United States. But Long says there is a clear rule in Tennessee.
There is a rule of conduct in Tennessee that says that a lawyer is prohibited from threatening a prosecution of a criminal charge in order to gain an advantage in a civil matter.
Long points to other state opinions. An Ohio Supreme Court opinion states it is improper for the prosecutor to offer to dismiss a criminal charge in exchange for the defendant's promise to sign a release of all civil claims. In Virginia, if a prosecutor knows that a charge is no longer supported by probable cause, she is obligated to dismiss the charge and may not condition that on dismissal of civil liability.
It's not too much of a stretch to say that there was pressure bordering on coercion, at least in this case.
Funk said the agreement was designed to bring closure to the case, and he did not want to deter victims from reporting domestic violence, adding it saved taxpayers the costs of defending against a federal lawsuit.
My initial gut reaction was, no, you take that deal and, shove it.
David Chase said he felt forced to take the deal and questions if justice was served.
I definitely know that his behavior was not ethical, wasn't fair.
Long says it would be up to the Tennessee Board of Professional Responsibility to investigate any ethics complaints filed in this matter. But he says this issue would be a first in Tennessee because it has never come before that board before.
All right. Thanks so much, Ben.